name of God, the compassionate, the merciful. Good evening, friends, and welcome to the 80th episode of Crime and Punishment, a legal podcast, not a political one. The official podcast of the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida, the website for which is augustusinvictus.com, and that is me, yours truly, the host of this program. We are simulcasting to a couple places, but I'd recommend you tune in on YouTube. It has the smoothest delivery. We've got some good news, we got some bad news. I'm going to switch to the camera. This is not my forte. All right. So the good news is we've got a green light from a publishing company for the Confessions. Bad news is Dr. Kaczynski died today. So a moment of silence for Dr. Kaczynski. We're going to talk about some other news. This is not going to be a program about Dr. Kaczynski or industrial society and its future. This is going to be a program tonight about legal news, as always, because we don't talk about politics here, or even anti-politics. We only talk about the law. This is legal marketing, so please don't ban us from YouTube. Where to begin? Let's begin with the title. The title of the episode. Let's read that article first, right? Politico states on Twitter, and if you're not on Twitter following me, you should go to Emperor Invictus. That's where you're going to find all these fire stories. Politico, unbiased journalists that they are, post, FYI, yes, Trump could run for president from prison. There are no legal obstacles to running for president as a convicted felon or from behind bars. Our story from April explains how it's been done before. You can always count on Politico to tell you the neutral news, right? Totally not cheerleading for the administration that has charged President Trump with a crime. So we have officially entered into the Banana Republic phase. That is the reason for the title of this program tonight. The DOJ has pressed charges against Trump. The subtitle for this Politico article: he could follow the playbook of the socialist firebrand Eugene V. Debs, who in 1920 received nearly 1 million votes while behind bars. Whoa, thank God. Thank God that a politicized Department of Justice won't get in the way of Donald Trump getting almost 1 million votes while behind bars. Perhaps you don't recall, dear audience member, the presidential reign of Eugene Debs. That's because Eugene Debs never won the presidency. So while it might not be illegal to run for office from behind bars, obviously it's an impediment. The indictment and other ongoing criminal investigations of Donald Trump raise the real, if still remote, prospect that a leading contender for the 2024 presidential nomination could face prison time. There are no legal obstacles to running for president as a convicted felon or even from behind bars. And if Trump finds himself in that predicament, he'll be following in the footsteps of another rabble-rousing populist and frequent presidential candidate, the avowed socialist Eugene V. Debs, who received nearly 1 million votes while in prison a century ago. Think about, let's do this thought experiment. You are alive in, 1987. And you're thinking of the Soviet Union and all the things that go on there. And where was it the other day? I was just hearing this. They thought in the Soviet Union that everybody here in America was starving to death. That we were all dirt poor. That we were just waiting for the day that we were allowed to escape the United States and run to Soviet Russia and the Eastern Bloc countries. And the point was made that they believed that over there because that's what their media was telling them. And the only people that knew otherwise were the people with banned shortwave radios they had to listen to under the covers, so that they knew what was actually going on in the outside world. So you can imagine the kind of propaganda going on in the Soviet Union where, if a political opponent in an election was jailed, well, that's okay. The media, the local media in your Eastern Bloc country is going to say, well, actually, people have run from prison before. Just because this regime in power, or this administration, excuse me, we don't call them regimes in democratic countries, just because this administration in power has jailed the leading contender against it, just because he could go to prison for that, doesn't mean he can't run for office. He has every right to run for office. That's where we're at now. And they'll just go on and on about, oh, well, other people have run from office too. Nobody you know that's won, right? Trump's escalating legal troubles are resurrecting that question. The question of what happens if an imprisoned candidate actually wins, right? Which is a different... Well, they use can of worms later. He has been indicted in New York for falsifying business records, a state crime that carries a maximum 4 years in prison when charged as a felony. Many experts contend that even if Trump is convicted, he is unlikely to see prison time because judges rarely sentence first-time offenders to prison for that type of felony. Just like the J6 defendants, most of whom were totally law-abiding with no records, went to prison. So yeah, judges rarely sentence first-time offenders to prison. That's true, but in a politicized case, they certainly do. So let's talk about the opening sentence here in this paragraph, that he's indicted in New York for falsifying business records, a state crime that carries a maximum 4 years in prison when charged as a felony. So the difference here is... it's a principle of federalism. You can be charged with a crime at the state level, and you can be charged at the federal level. So, take Derek Chauvin, for instance, a very vivid case from the recent past. He was charged in state court for the murder and manslaughter and several other things concerning George Floyd, and the feds didn't do anything. They waited to see how the state trial was going to come up, how it was going to end up. And you heard us talking about it here on Crime and Punishment. The feds were waiting outside the courtroom. They thought that there was a very good chance that Derek Chauvin could have walked on that case, and they were waiting outside the courtroom to arrest him on federal charges. So just because you won the state trial doesn't mean that you're going to win the federal trial. Look at the case of James Fields. Charged in that incident in a Virginia state court. New U.S. attorney comes in, charges him with a federal crime, which he later took a plea to after losing the trial in the state court. So, in this situation with Trump, he's been indicted in New York on a state crime. But there are also federal issues. So you can be in two different courts at the same time. Many experts contend that even if Trump is convicted, he might not go to prison because judges don't sentence people to prison for the first time. But 3 other ongoing criminal investigations of Trump, one in Georgia for election interference and 2 from special counsel Jack Smith in Washington, could trigger more serious felony charges and carry a higher risk of prison. A Trump electoral victory from behind bars would open a constitutional can of worms, but the general view among legal scholars is that the need for a duly elected president to fulfill the duties of office would override a criminal conviction and require the sentence to at least be put on hold. And if Trump were convicted of a federal crime, he could even try to pardon himself immediately upon taking office, a maneuver that Debs himself promised to undertake if he won. then we're just going to get into uncharted waters. Seton Hall law professor Eugene Matzo said, I don't think we have an answer to this. Don't we? We haven't seen this happen in Latin American countries over the past century. We don't know what's happening here. This is just unprecedented in world history. It's unprecedented in American history. Certainly not unprecedented in the history of the Western Hemisphere, and we were the ones causing it a lot of the times. We, not us lawyers, of course, we Americans were the ones overthrowing countries of Latin America. We know full well that, Latin American dictators or presidents or whatever you want to call them will jail their political opponents. We talk trash about it all the time. Look at those banana republics. They have no rule of law down there. They're jailing their own political opponents. Now it's here. What an historic time we are living in. I talk about the ancient Roman proscriptions a lot on this program. I've talked a lot for years about how our system of government is patterned off of the ancient Roman Republic. So one of the things we've all been waiting for is the age of proscriptions, when a new consul or new dictator would come in and just wipe out all of his political enemies. All of their property would escheat to the state or be divided among their friends. So the most famous example of this was Sulla. I've mentioned that before on this program. Julius Caesar, a young Julius Caesar, had to run for the hills because Sulla told him to get divorced. And Caesar refused and literally ran into the hills with his wife, refusing to get divorced. Cost of Glory. If you go to Twitter at Cost of Glory, they've got a brilliant podcast, and actually they just did one on Sulla. They don't liken it to modern day politics and what's going on right now. That's my job. What we're talking about I'm not in Cost of Glory. I have nothing to do with it. I'm just a big fan. So I would strongly recommend you go to Twitter, find Cost of Glory. You can go to Spotify, find it. Vivid storytelling, great, just a phenomenal program. Also a great introduction and a great program for those of you who already know Greco-Roman history. And I think you should listen to it just so you have some background on what's going on in America right now. Because everybody was just up in arms when he was charged in New York. And now everybody's up in arms now that he's charged with a federal crime. This is totally unprecedented. No one's ever done this to a former president before, so on and so forth. If you know history, you saw this coming 20 miles away. This had to happen. Had to. And now we're here. What an epic time to be alive. Aleph, the Nemesis. Good evening, gentlemen. Hope all is well with you and your families. Back at you, buddy. Garfield. Thank you for joining, Garfield. White Student Transmission. Good evening, buddy. Dutch Schultz says hello from Detroit. Well, hello from Orlando, Florida. Aloha, Coach Alpha Elite. Yes, please do hit like. I'm terrible at doing the marketing aspect of this. But if you hit like and subscribe and all that, that would, I think, boost the algorithm, as they say. So that's what's going on in Trump world. What an amazing time to be alive. Got a whole bunch of other stuff like this. 1 year since Johnny Depp won his trial and proved that he was defamed and proved that he was set up. God bless him. Let's see. This is an important one. Let's go to Reuters. Reading Reuters and Politico tonight. Super left-wing night tonight. Don't ban us from YouTube. This article came out earlier this week. What day was it? Tuesday. The U.S. cannot ban people convicted of nonviolent crimes from owning guns, says an appeals court. Again, bad headline, but great news. The U.S. government cannot ban people convicted of nonviolent crimes from possessing guns, a federal appeals court ruled on Tuesday. The 11-4 ruling from the Philadelphia-based 3rd U.S. Circuit Court of Appeals is the latest defeat for gun control laws in the wake of a U.S. Supreme Court ruling last year expanding gun rights nationwide. Interesting that it's Philadelphia. Interesting that they find this to be a gun control law. And it will be more apparent why later. So here's the distinction. If you have a violent conviction, you're convicted of a violent crime or you're convicted of a non-violent crime, it doesn't matter. You are not allowed to possess firearms. That's life. But now this ruling says, hold on a second. There's definitely a distinction between a violent crime and a non-violent crime. If you possess a tablet of Xanax, that's a non-violent crime. You should not be allowed to have a firearm because of that conviction. You are convicted of tax evasion, non-violent crime. So you should not be able to go hunting with your son. You are convicted of, everything is a felony now. You're convicted of, I don't even know, driving on a suspended license for the 3rd time, right? Non-violent felony, you should not be able to own a firearm. It used to be that a felony was something for which you would be hanged. Burglary of a person's home, robbery, rape, murder. These were the most serious of serious crimes. If you committed these and were convicted, you would be hanged. That's what felony meant. Now, felony just means you get a year and a day in jail, or in prison, excuse me. And a misdemeanor is you get up to a year in jail. That's the distinction now. But that petty distinction is what prevents you from having a firearm. That's why it's a gun control law. Because if you make everything a felony, and a felony conviction means you cannot have a firearm, well then of course everything should be a felony. So then nobody has firearms. That's how we came to this police state. So the liberals saying we champion the poor, we champion the rights of the downtrodden, etc., they've been on board with this ostensibly conservative/Republican move to make everything a felony because it disarms everybody. That's why it's a gun control issue. The decision stems from a 2020 lawsuit by a Pennsylvania man, get this, Brian Range, who was barred under federal law from possessing a gun after pleading guilty to, of all things, welfare fraud. He claimed that the prohibition violated his right to bear arms under the Second Amendment of the U.S. Constitution. So the guy is convicted of welfare fraud and is not allowed to have a firearm. Totally unrelated. Now, if you were convicted of robbing a bank with a gun, okay, we could talk about how you have abused your Second Amendment right. You're convicted of welfare fraud. I mean, chances are you're poor, and this is the reason you did it, not because you're a violent felon who uses guns to commit crimes. So why would the Second Amendment not apply to you? Range's lawyer, quote, "We are very pleased that the Third Circuit has vindicated the rights of our client by faithfully applying the Supreme Court's decision. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, which enforces federal gun laws, declined to comment." Boy, imagine all the power they're going to lose from this rogue Supreme Court. Range pleaded guilty in 1995 to committing welfare fraud in Pennsylvania in order to obtain $2,458 of food stamps, a misdemeanor punishable by up to 5 years imprisonment. he was sentenced to 3 years of probation. So, what I said earlier about the division between misdemeanor and felony, that applies to Florida law. Some places your misdemeanor can be punishable up to 5 years. Apparently that includes Pennsylvania. I'm not a Pennsylvania lawyer, I have to give you that disclaimer. Federal criminal law generally bars people convicted of crimes punishable by more than a year in prison from possessing guns. Such crimes are usually felonies, but the law also includes some state misdemeanors, like ranges. A federal judge ruled against range in 2021. Last June, however, the U.S. Supreme Court ruled that the Second Amendment protects individuals' rights to carry guns in public for self-defense, and that any restrictions on that right must be consistent with the nation's historical tradition of gun regulation. And the undertone here being banning people from possessing guns because they had a nonviolent criminal conviction is absolutely not consistent with the nation's historical tradition of gun regulation. Circuit Judge Thomas Hardiman wrote for the majority on Tuesday that the government had failed to point to any laws from the United States founding establishing a tradition of disarming nonviolent criminals. But, as we said, this is an 11-4 decision, right? So 4 judges dissented. Quote, where, as here, the legislature has made a reasonable and considered judgment to disarm those who show disrespect for the law, it is not the place of unelected judges to substitute that judgment with their own, end quote, wrote Circuit Judge Cheryl Ann Krause, one of the dissenters. These are, of course, the same people. We need to disarm people who show disrespect for the law. These are the same people who say we need to give the right to vote to those who disrespect the law crossing the border illegally, who are here present in the United States illegally by the millions. Same people. Not the place of unelected judges to substitute that judgment, that is the judgment of the legislature, with their own. These are the same people who say that that's exactly the role of activist judges. That's why they're on the bench, so they can legislate from the bench, so they can overrule the legislature when their unconstitutional laws get passed. That's how Roe v. Wade came into existence. Because unelected judges do substitute their judgment for the legislatures. These are the same people. Absolute logical inconsistency. So, good news is, though, this U.S. Supreme Court decision saying that we are allowed to carry firearms, it is now being implemented, and in all places. Philadelphia. How about that? So that's some good news. Let's see what else we have here. Let's go back to the chat here. All right, we'll get some questions. It has been a while, Mr. Invictus. Greetings from Texas. Greetings from Florida, Mr. Robbins. Oh, Mr. Robinson. Yes, we have video now. You missed last week's class. I got guilt-tripped into it by my business mastermind. Said I have to use video. So here we are. Article is available on NBC News. People convicted of nonviolent crimes, says Coach Alpha Elite. You know what? Good call. Let me, I'm actually going to I'm going to post the link in the chat from the Reuters article I was reading. I should have done that while I was reading it. That would have been smart. White student transmission wondering about parking tickets. I don't think they've raised parking tickets to felonies yet, but exactly. Good point. It could be anything. Everything's a felony now. Robertson, is it at all possible or realistic to push any kind of reciprocity law that would prohibit lawmakers in states that support gun control from having armed security? Short answer, I don't know. Let me put that in my pipe and smoke it. Good question. And who selectively don't enforce the law in states with globally funded DAs. Yeah, again, same people who implemented sanctuary cities for people who disrespect the law. Same people who refused to who was that guy in Tampa? There was a state attorney here in Florida who said he was going to refuse to enforce the laws that were passed by the legislature because he didn't agree with them. DeSantis removed him. The guy sued, and the courts said, "Are you crazy? Your entire job is to enforce the laws. You can't just enforce the ones you don't like. You can't just refuse to enforce the ones you don't like." Right? Same people. Congratulations on your new child, my man. All right, let's see what other kind of articles we've got here. All right. We've got an ABA article on something they're actually doing that's useful. Ooh, and then the Oath Keepers, which it makes sense to talk about that the same day we talk about Trump's indictment. So the ABA Journal, my favorite punching bag. ABA is the American Bar Association. It used to be the standard for the legal profession. Now it's like everything else. Everybody needs to be gay. You need to hire more women than men. 50% at least of the articles here are about diversity and law firms making, moves to make their law firms more diverse. And if they're not, they should be. And everything's a rainbow flag. It's just, this used to be the flagship for the legal profession. It's a sad swan dive. Plea bargain. This is a good one, though. They finally put out a good article for the first time in the last 5 years. Plea bargaining reform urged by ABA task force in new report. You might remember we read from a book a few months ago on plea bargaining and how it came to be so dominant in America. The opening of that book is a criminal trial, if I recall correctly, in Massachusetts, where the guy wanted to enter a plea to a crime he had committed. He wanted to say, yes, I did that, enter a plea of guilty, and take the sentence that was offered rather than go to trial. And the judge had him evaluated for sanity, for competency to stand trial. Thought, why would you not want the government to prove that you did this? You must be mentally ill. So I'm going to have you evaluated by a doctor to make sure you're competent to proceed to trial. That was how completely extraordinary it was to try to enter into a plea. Now, everybody enters into a plea. Over 90% of these convictions are pleas. And that's because you are given a trial penalty, right? You're looking at 30 years in prison, and the state attorney comes and offers you probation. A reasonable person is going to take that because they don't want to go to trial and risk going to prison for 30 years. Even if it's something they didn't do, they will not go to trial and risk 30 years in prison when they could just take the probation. I did, but that is, an extraordinary case. Most reasonable people, when faced with a dilemma like that, they'll take the probation, even if they didn't do it. More commonly, you get things like the guy scores 15 years in prison. That's what he's looking at. And the state offers him, 5 years. Decent deal. He could fight it out in court or he could take the deal. And a lot of people do take the deal, which I have absolutely no judgment for that. No judgment of those people. I saw it every single day that I was in jail. People taking pleas to things either they didn't do or that they didn't do to the degree they were accused of. And they did it because you see it in real time. Their entire lives falling apart around them. They lose their truck, got repossessed. They lose their apartment. Don't have anybody to take their kid to school. He's a single father. Can't take his kid to school. How's she going to eat? How's she going to survive without him? So they take the plea to get out of jail fast. That's what plea bargaining has become today. Especially if you're being held without bond. They know they've got you, and they know that your life is falling apart, and they know that you're going to take the plea. once they pressured you enough. That's what it has become. And that's not what it was meant to be when it first started. Anyway, that's all my commentary. Let's read the article. An increasing number of criminal cases are not going to trial. Again, ABA has a talent, a supreme talent for catching on to things, years late. An increasing number of criminal cases are not going to trial, and the implications have negative consequences for the entire justice system, according to a new report by the ABA Criminal Justice Section's Plea Bargaining Task Force. In fact, I'll share this with you because the hyperlink is in there so you can read the report itself if you want. The task force, which included prosecutors, judges, defense attorney, and other stakeholders, found that about 98% of convictions are the result of a guilty plea. A practice that they say often coerces innocent people into pleading guilty to crimes they didn't commit to avoid jail time. Like we've said on this program 1,000 times. Among other conclusions, the report determined that, on average, defendants received 7 years less when they accept a plea instead of risking a harsher sentence by taking their case to trial, a trade-off commonly referred to as the trial penalty. So now you've heard that twice. Trial penalty. So they will offer you a plea deal, and if you don't accept the plea deal, they say, all right, offer's off the table. You're looking at the maximum now. We're going to argue for the maximum. It's a dirty trick, but that's prosecution 101. You make me waste my time taking this to trial. I got other cases. And I've got you dead to rights. You're going to accept this plea, or I'm going to take all plea offers off the table. You're looking at 30 years, buddy. Take the deal. That's the trial penalty. Quote, no one should be afraid to go to trial, says Wade Roll, a Jacksonville, Florida lawyer who specializes in criminal defense but was not a member of the task force. Quote, what the justice system should not be doing is taxing people for exercising their constitutional rights, end quote. Couldn't agree more, Wade Roll. The 3-year study also found that black people are more likely to accept a plea because they're more likely to be stuck in pretrial detention. And plea deals make it harder to uncover racial bias and police misconduct, according to the report, because trials offer transparency and critical oversight of the criminal justice system. A lot to unpack there. First of all, let's just agree. It probably is more difficult for black people. It is more that black people are more likely to accept a plea because they are more likely to be stuck in pretrial detention. I would agree with that. Just anecdotally, I don't know the stats. I didn't do the statistical study, but anecdotally, I'd say that's probably true. On the one hand, because black people are socioeconomically disadvantaged and sometimes can't make the bond payment. A lot of times, the white people can't either, but their families will pay for it. So you do have a racial disparity where if there's a charge for a bond and they can't afford it, they're stuck there. That's a fact. It's not an anti-white discrimination thing to say that. Poor people have trouble getting out of jail for pretrial. You can file a motion to reduce bond, prove the inability to pay, but who's going to do that? Your public defender, who himself has 300 other cases just like yours, he doesn't have the time to be doing stuff like that. So if you can't hire a private attorney who's going to file a motion to reduce your bond or let you be released released on your own recognizance, then how are you going to accomplish that? You're just going to sit there till trial. More likely, you're going to sit there until you take a plea to get out because trials take forever. What's the next thing? Plea deals make it harder to uncover racial bias and police misconduct, according to the report, because trials offer transparency and critical oversight of the criminal justice system. Agree and disagree. Trials maybe do offer oversight, but do they really? It's a lot easier to get your story out if you do have a trial and here's the part I fully agree with, that it does make it harder to uncover police misconduct when you take a plea. One of the elements for malicious prosecution, I tell this to everybody who calls me, is you have to prove you are actually innocent. If you have a plea deal, it doesn't matter how good that deal is. You could get probation, you could get time served. You could even go into a diversion program and you have no conviction at the end of it. They'll null pros your case, they'll dismiss your case at the end of it. Doesn't matter. You entered into a plea deal. That means you cannot prove actual innocence. That means you cannot sue the police. So you've got to go all the way if you want to sue the police, if you want to prove there was police misconduct, if you want to prove racial bias, if you want to prove whatever it was that, was wrong or corrupt for the government to do, you have to win. There are no half measures. There's no escape valve. You have to go all or nothing. Or you can't sue anybody and you can't allege any police misconduct. Those are the stakes. While the report acknowledged that the plea bargaining system has benefits, including efficiency and cost saving, I agree, it found that under the current system, the costs outweighed the positive aspects. Quote, to this end, jurisdictions should establish mechanisms to monitor the plea process from charging decision to disposition, as well as implement an audit process to test the validity and integrity of guilty pleas, end quote, according to the report's authors. Here's one problem with that. It's an imperfect system. You'll never find a perfect solution except maybe trial by combat. It's an imperfect system. If you have an audit process to determine whether the guilty plea has integrity, then you're going to be forcing people to go to trial who don't want to go to trial. And you could very well be imposing a trial penalty against their will. Some people want to take probation, or they want to take the time served instead of going to trial on it. And that's really their prerogative. It's their life that's being ruined by the government. So if you force an audit process and say, no, this guilty plea has no validity, then what? You're going to force that person to go to trial and get the trial penalty and go to prison for 7 years when they could have taken probation? There are no perfect solutions except for trial by combat. But good to see that the ABA is finally doing something worthwhile instead of just trying to shove gayness down our throats all the time. Bravo. So, let's go to the chat. We got one more article for the night. Lack of symmetry. I don't know what you mean, Mr. Robertson. Rest in peace, Dr. K. Dr. Kaczynski. Yes, if you were late to class today, thank you, Jason. If you were late to class today, Dr. Kaczynski has died. We had a moment of silence at the beginning of the program. But we are not talking about his works today. This is a legal program. We are instead going to talk about something in line with our opening article. Oath Keepers founder gets 18 years in prison. The longest January 6th sentence yet. This is actually a couple weeks old. This is from May 25th. I've had it in here, meaning to do it. Maybe I'm just too depressed by it to address it. 18 years in prison. The founder of the far-right militant Oath Keepers, Stuart Rhodes, was sentenced to 18 years in prison on Thursday, that is, back when this was written in May, for seditious conspiracy, the longest sentence imposed to date over the January 6th U.S. Capitol riot that sought to keep Donald Trump in the White House. I love how they spin this. I love how they characterize it. It's not a protest of an election that was stolen, which we're not arguing. Don't ban us from YouTube. It's not a protest of a stolen election, which is what Donald Trump and the Oath Keepers and everybody else said they were doing there. No, it's a riot that sought to keep the president in the White House, even though he wasn't president anymore, right? U.S. District Judge Amit Mehta delivered the sentence after a defiant Rhodes stood before him in an orange jumpsuit and claimed he was a political prisoner who, like Trump, was trying to oppose people who are destroying our country. Unrepentant. How dare he say that he's a political prisoner? For decades, Mr. Rhodes, it is clear you have wanted the democracy of this country to devolve into violence, Mehta told him. I dare say, Mr. Rhodes, and I've never said this about anyone who I've sentenced, you, sir, present an ongoing threat and peril to this country, to the Republic, and the very fabric of our democracy. Not since the days of Thomas Jefferson and Aaron Burr have we had words like that. Not American to American, anyway. Rhodes, a former Army paratrooper turned Yale-educated lawyer, was convicted in November by a federal court jury in Washington. Rhodes' prison term represents the longest sentence for any of the 1,000-plus people charged in connection with the January 6, 2021 Capitol attack by supporters of Republican then-President Trump in a failed bid to block Congress from certifying Democratic rival Joe Biden's November 2020 election victory. In case you missed the subtext from the paragraphs before, this was a riot. It wasn't a protest. The whole thing is a big lie. This guy deserves to go to prison for 18 years. Until now, the longest sentence was 14 years in prison, given to a Pennsylvania man who attacked police during the rampage. Prosecutors had sought a sentence of 25 years for Rhodes. The federal prosecutor, Catherine Marcosi, said, Mr. Rhodes led a conspiracy to use force and violence to intimidate and coerce members of our government into stopping the lawful transfer of power following a presidential election. As the court has just found, that is terrorism. Rhodes expressed no remorse and instead accused the far left of destroying America. Quote, I believe this country is incredibly divided, and this prosecution, not just of me, but of all J6ers, is making it even worse. I consider every J6er a political prisoner, and all of them are being grossly overcharged. End quote. Actual terrorism. He also vowed to expose the criminality of this regime from his prison cell. I mean, Dr. Kaczynski did write a new book from prison, Anti-Tech Revolution. I don't know how Mr. Rhodes is going to expose the criminality of this regime from his prison cell. It's a very difficult thing to do, but Godspeed, my man. You know, when they first went on trial, and now that this has happened, your initial reaction might be, as mine was, to be honest, well, good thing they threw all those white supremacists under the bus. Good thing they separated themselves out from all those horrible white nationalists, those evil racists. That helped them out a lot. Be that as it may, I haven't talked to Mr. Rhodes since, 2017, to be quite honest. So I don't know what he's thinking now, but I imagine he probably knows now what the score is, and I imagine he's got bigger things to worry about now. So, I would counsel you all not to hold any grudges against the Oath Keepers. This is a bad day for everybody. Regardless of who was right or who was wrong, or who threw who under the bus, who threw whom under the bus, it's bad news for everybody. In addition to seditious conspiracy, a felony charge involving attempting to overthrow, put down, or destroy by force the government of the United States, Rhodes was convicted of obstructing an official proceeding and tampering with documents. Rhodes was acquitted of 2 other charges. Rhodes, who wears an eye patch after accidentally shooting himself in the face with his own gun, founded the Oath Keepers in 2009. Nice little dig there by the liberal writers at Reuters. Totally unnecessary. The militant group's members include current and retired U.S. military personnel, law enforcement officers, and first responders. They have appeared, often heavily armed, at protests and political events, including racial justice demonstrations that followed the 2020 murder in Minneapolis of a black man named George Floyd by a white police officer. It's like they're writing this for aliens that have come down to Earth. Like, who doesn't know? The murder of a black man named George Floyd. Yeah. You'd literally have to be from Mars not to know what happened there. Meta, also on Thursday, sentenced co-defendant Kelly Meggs, a former Florida chapter leader, also convicted of seditious conspiracy, to 12 years in prison. Prosecutors asked Meta to sentence Meggs, the group's former Florida chapter leader, to 21 years in prison. Although Meggs' family members urged the judge to look at the defendant's good qualities as a protector and provider in his role as a father, brother, and husband. Meggs' wife, Connie, was also separately convicted in a different trial with other associates of the Oath Keepers for their roles in the Capitol attack. The Capitol attack. Not just a riot. Not a protest, certainly. Not even just a riot. It's an attack. An attack at the heart of our democracy. I truly apologize for being there, Kelly Meggs said through tears. It has not only destroyed my life, but the life of my entire family. That's exactly what Big Brother wants to hear. That we all learned our lesson, that none of us are political anymore. This is, after all, just a legal podcast. We don't talk about politics here. Protesting something as important as an election that was allegedly stolen through mail-in ballots, absentee ballots, voter fraud at the machines that were rigged. Allegedly, we don't take a position on that, but protesting something that important will destroy your life and the life of your entire family. That's the message that everybody wants to get across here. Meggs admitted that he should never have entered the Capitol grounds, but he nevertheless denied that he planned his actions in advance, and he blamed his vile and hateful language for leading to his conviction. Meggs, who in addition to seditious conspiracy was also convicted of 4 other felonies, including obstructing an official proceeding, led a group of Oath Keepers clad in paramilitary gear into the Capitol on January 6th. Others, meanwhile, staged a quick reaction force at a hotel in nearby Arlington, Virginia. The prosecutors said was equipped with firearms that could be quickly transported into Washington. Although attorneys for Rhodes vowed to appeal the conviction, they told reporters outside the courthouse that they were pleasantly surprised that Meta did not impose a stricter sentence. This is journalism now. Let's go back to the chat here. We got 10 minutes left of the program tonight. Maybe let's just chat a little. What a depressing story to end on, right? John Gordon Mead says, this is a disgusting story and just goes to show how much a small group of certain creatures hate us normal people. Yes, certain creatures called feds. White student transmission. This is so messed up. Yeah. This guy, whose name I never say on air because I don't know what profanities lie therein. You look like you've been working tirelessly, he says. Thank you for all your hard work. Well, thank you. I have. I wish I could say it was all legal work. A lot of physical training all week. I kind of like doing Crime and Punishment at the very end of the loop. This is the last thing I do. I've got the prayer hour, when this ends, but this is the last thing for work I do for the entire week. I think I like having it Saturday nights. It's better than just dividing it in the middle of the day, stopping everything, dropping everything. Nope, can't answer your phone call, Judge. I'm in the middle of Crime and Punishment. I like doing it Saturday nights. It's a lot more laid back. Not running. Kids are asleep. I like ending the week like this. I think we might keep this up. A lot more chat engagement, too, than on a Tuesday or Wednesday afternoon at 3 o'clock in the afternoon, So I like this little hangout with our jazz music. Mr. Robinson, is there any chance the history and tradition standard advanced in Bruin could apply to other protected rights beyond the second? If so, maybe many laws could fall. Yeah, I think that's what the Supreme Court is up to right now. They're trying to do it slowly but surely, but right after Roe v. Wade was overturned, immediately Justice Thomas jumped on that and said, all right, well, let's get rid of sodomy next. And what was it? Contraception. Time to revisit the sodomy and contraception laws now. Because we're going to admit that Roe v. Wade was wrong, that the U.S. Supreme Court abrogated authority it didn't have to legislate to all states, that something that was essentially and obviously a states' right issue, then why would we not say the same for sodomy and contraception? And then the Second Amendment ruling came out. So yes, that's the thing. If they keep getting these cases, it could all turn around. Freedom Falcon. Hey, Freedom Falcon. Long time no see. Pour one out for a real one we lost today. Yes. Rest in peace, Dr. Kaczynski. White Student Transmission. Agreed. Thank you for all you do to help us. Thank you, my man. Thank you. And, I think we'll end a few minutes early. Maybe do some extra jazz tonight. I don't know. Just hold your horses there. All right, well, I think that's pretty much all we've got for tonight's program. Oh, I did have another set of amazing articles about the former district attorney in San Francisco. He was removed in a recall vote, removed from office because he just absolutely refused to enforce the laws. Was just letting people go left and right. Just son of 2 Weather Underground members, amazing, becomes the prosecutor for San Francisco, and then implements this radical plan to just not prosecute crimes in San Francisco. So he was removed from office, and guess what? Berkeley makes him, appoints him the head of their criminal justice department at the law school. So I'd love to get into that, but didn't transfer them from my phone. So yeah, we'll just end there tonight. How about that? So let's cue this music here, and we will see you all next week. Till then, everybody.